Good morning, everyone. Thank you for being here. My name is Meredith Holland-Kessler, and I'm a staff attorney with the Religious Liberty Clinic here at Notre Dame Law School, and it is my great pleasure to moderate today's panel on persons in international law. Each panelist will present his or her paper, and then we will have about 15 minutes for questions and answers. First, we have Francis Beckwith, who is a professor of philosophy, affiliate professor of political science, and associate director of graduate studies in philosophy at Baylor University. Among his over 20 books are Defending Life, A Moral and Legal Case Against Abortion Choice, and Taking Rights Seriously, Law, Politics, and the Reasonableness of Faith, both published by Cambridge University Press. His most recent book is Never Doubt Thomas, The Catholic Aquinas as Evangelical and Protestant, published in 2019 by Baylor University Press. A graduate of the Washington University School of Law in St. Louis, he earned his PhD in philosophy from Fordham University. And Professor Beckwith will present his paper on Dignitatis Humanae and the challenges of the new modern world. Second, we have Francesca Matozzo, my colleague, and a legal fellow at the Notre Dame Law School Religious Liberty Initiative, where she supervises students on domestic litigation and matters involving international religious persecution. Before that, she litigated for the U.S. Department of Justice Civil Division and clerked on the U.S. Court of Appeals for the Third Circuit and the U.S. District Court for the Southern District of Texas in Brownsville. She received her Juris Doctor from Notre Dame Law School and her Bachelor of Arts in English from Providence College. Francesca will discuss moral reasoning in the law and the human person. And last but not least, we have Professor Pedro Pallares-Yabur, who is a professor of law at Universidad Panamericana in Mexico. He teaches philosophy of law and human rights. He earned his law degree at the same university and his JSD at Universidad de Navarra in Pamplona. His research interests include the drafting process of the Universal Declaration of Human Rights, the philosophical foundations of these rights, and the role of Charles Malik in the drafting process of the UDHR. He has translated into Spanish two important books on human rights, A World Made New by Marianne Glendon, and What It Means to Be Human by Carter Sneed. Professor Pallares will present his paper entitled Dust Will Be, But Dust Whose Love Still Grows, Charles Malik, Dignity and Tension, and the Foundations of the UDHR. Please join me in welcoming our panelists.
All right, good morning, everybody. I've got a very large paper and 20 minutes to describe it to you and tell you about it. The title, as Meredith said, is Dignitatis Humanae and the Challenges of the New Modern World. The Second Vatican Council published its Declaration on Religious Liberty, Dignitatis Humanae, on December 7th, 1965. At the time, it was seen by many as a significant departure from the Catholic Church's long-held magisterial teachings on religious liberty and the relationship between church and state. Okay. Whoops. Oh, well. Nevertheless, there is little doubt that Dignitatis Humanae constituted a development in Catholic doctrine, one that moved the church in the eyes of some closer to a kind of Lockean claim on matters concerning church and state. But one of the things that stands out about the Declaration is that it itself claims that the religious liberty that it's defending relies on the church's own perennial understandings of human nature and the divine law, neither of which fits comfortably in John Locke's scheme of things. As with all the documents of the Second Vatican Council, Dignitatis Humanae was intended to confront the challenges of the modern world while safeguarding the deposit of faith. The modern world, at least in the West, had made its peace with religious liberty, having grown weary after centuries of conflict stemming from the ecclesial divisions that resulted from the Reformation and later experiencing the rise of anti-religious totalitarian regimes in the 20th century. So in the early 1960s, the modern world that Dignitatis Humanae confronted was one in which religion and religious liberty were seen through two historical trajectories, one backward-looking, one forward-looking. The backward-looking one was the lived experience of the North American and European states that had settled on a variety of modi vivendi reflected in various legal instruments and international declarations that sought to accommodate their people's religious diversity. And secondly, the present experience of nations behind the Iron Curtain that were effectively atheistic regimes that sought to suppress for the purposes of ultimately eradicating their people's religious beliefs and practices. Although Dignitatis Humanae, I believe, masterfully came to terms with both trajectories, the modern world that gave them salience, like pet rocks and bell-bottom jeans, is no longer with us. Do you guys remember pet rocks and bell-bottom jeans? I do. Our new modern world is much different. It is one in which the very idea of religious liberty as an essential component of social justice is increasingly questioned. The premises on which Dignitatis Humanae relied on are no longer dominant in the academy or in the wider culture. What was once, just a generation ago, hailed as the Council's most significant concession in its encounter with modern thought seems now to be out of step with current trends. So what I want to do, instead of giving a kind of long exegesis of Dignitatis Humanae, I want to just go through certain points that the document affirms about the nature of religious liberty and how it's tied into the church's own self-understanding of its anthropology. And then I'm going to move on after that to talk about two different types of challenges to the understanding of religious liberty found in Dignitatis Humanae. One I call hegemonic liberalism, and the other I call eliminative egalitarianism. So, the central points of Dignitatis Humanae. First, religious freedom depends on a specific philosophical anthropology, a view of human nature that is broadly Catholic, but can be defended or can be known, according to the document, by unaided reason and or divine revelation, and can be found in the Church's tradition. This anthropology entails the dignity of the human person. Third point, this dignity comes from the human person's natural capacities for reason and free will. This anthropology presupposes the existence of a natural moral law. The natural moral law depends on several goods to which human beings are ordered. Among these goods is the good of fellowship with God. God has provided a means by which we can have this fellowship in its fullest, the Catholic Church. Thus, the Catholic Church is the one true religion. One of the things that Dignitatis Humanae had to deal with and sort of separate itself from some of the more well-known sort of liberal defenses of religious liberty was to sort of ward off religious indifferentism and at the same time allow for protection of conscience. And so it does this in a very, I think, masterful way. It affirms the truth of Catholicism while at the same time saying that nevertheless, if an individual does come to conversion, it must be as a result of their own reason and free will. And obviously, grace is involved as well. We don't want to commit the Pelagian heresy by accident. God has provided us a means by which we can have this fellowship, as I've already mentioned, the Catholic Church. Because we are ordered towards fellowship with God, it is our duty to pursue religious truth. Because the assent to religious truth depends on the proper exercise of reason and free will, we cannot fulfill our duty unless we have religious freedom. Thus, state coercion on religion is a violation of human dignity and thus unjustified. 10th point, the Church has erred in the past by engaging in activities that are contrary to the dignity of the human person, including the suppression of religious freedom. There's a passage in Dignitatis Humanae which is as close as the Church comes in the document in saying, we've learned from experience that the other arrangements in the past, confessional states or integralism, do not work. Do not work. The freedom of religion extends beyond the individual to include corporate rights, including freedom of the church, and the rights of families to direct their children's religious education. So it's another thing that's important to remember with Dignitatis Humanae, it's just not an individual right, it's a corporate right. That is, that there's a freedom for the church, and that there's a kind of realm in which the church should, or religious organizations should operate, that the state, in a sense, is incompetent to make any judgments. Because religion is outside of the state's jurisdiction, no state, including a Catholic state, is an absolute sovereign over the lives of its citizens. Nevertheless, because religion is a human good and a just state should advance the common good, a just state should show religion favor. The state may only restrict religious practice if the conduct threatens public safety, public morality, or the administration of justice, all of which are based on the natural moral law. So that's, in a nutshell, it's like 14 propositions or assertions about what Dignitatis Humanae affirms about religious liberty. Tightly tethered to a Catholic view of anthropology, assumes that everyone has a duty to God, that the church itself, a religious organization, should be insulated, that they've got their own sort of domain or sovereignty about religious matters, and that something that is also important, part of the corporate rights also involve the rights of families to educate their children consistent with their religious tradition. So today's challenges to Dignitatis Humanae. I mentioned two of them, hegemonic liberalism and eliminative egalitarianism. So in order to understand hegemonic liberalism, I want to talk a little bit about sort of conventional political liberalism that roughly comes out of post-1960s philosophical literature. So starting roughly in the mid-1960s, philosophers and legal scholars began developing arguments to defend a kind of anti-perfectionist liberalism that would find its way into the wider culture and eventually into most legal systems in the West, including the U.S. constitutional law. Among the thinkers associated with this movement are John Rawls, Ronald Dworkin, Bruce Ackerman, Thomas Nagel, and so forth. Even though they and their allies disagreed on certain conceptual and practical questions, they did share a common aim: to establish a culture and law, a view that as a matter of political justice, the state should remain neutral between, to use Rawls's language, reasonable comprehensive doctrines when legislating on matters of constitutional essentials, i.e. fundamental rights. In practice, this means that the government may not pass coercive laws based on contested, though reasonable, religious or secular worldviews, such as Christianity, Islam, Marxism, or utilitarianism, unless those laws are based on what Rawls calls public reasons, grounds that could be accepted by any rational adherent of any reasonable comprehensive doctrine. Thus, for example, it would be a violation of political justice for a government to ban obscenity or recreational drug use based on exclusively on Christian moral theology, the Quran, Marxist class theory, or Benthamite utilitarianism. Consequently, absent a public reason, the state may not use coercive laws to advance any one particular vision of the good life as normative for all citizens. For lack of a better term, I'll call this political liberalism, which is the title of Rawls's 1993 book. Although arguably the most well-known defense of this view on a matter of a publicly contested issue occurred in December 1996 when Dworkin, Rawls, Nagel, and other philosophers submit an amicus brief to the U.S. Supreme Court in the case of Washington versus Glucksberg. The question before the court was whether the Due Process Clause of the 14th Amendment included a right to physician-assisted suicide. They published, it was called the Philosopher's Brief, not referring to undergarments. The document was submitted to the Supreme Court, and the Supreme Court 9-0 ruled against the philosophers. But it offered a case for physician-assisted suicide that relied on the premises of political liberalism. The authors write, so this is what they wrote in it, quote, "Different people of different religious and ethical beliefs embrace very different convictions about which way of dying confirms and which contradicts the value of their lives. None of these dramatically different attitudes about the meaning of death can be dismissed as irrational. None should be imposed either by the pressure of doctors or relatives or by the fiat of government on people who reject it." So according to its advocates, political liberalism is primarily motivated by the deep pluralism that is bound to arise in a free society. Equally informed citizens who are equally rational or come to different conclusions about what constitutes the good life. Now, there's much in political liberalism for Catholics not to like, and there's an argument to be made that its project was always unsustainable or a ruse for more nefarious totalitarian ends. But it does seem to suggest, though, at first glance, that our public institutions ought to embody a kind of epistemic modesty when it comes to coercive laws that concern those issues that deeply divide us. Dworkin is a famous quote from Ronald Dworkin. He says, quote, "A tolerant secular society could have no reason for embracing freedom of Orthodox worship without also embracing freedom of choice in all ethical matters, and therefore freedom of choice with respect to the ethical values that are plainly implicated in decisions about sexual conduct, marriage, and procreation," unquote. So it seems that under a fair interpretation or a generous interpretation of political liberalism, that a Christian baker should not be coerced to design a wedding cake for a same-sex couple, that Catholic hospitals should not be forced to offer abortions and transgender procedures, that parents should not be prohibited from being informed about what lessons their children are being taught in their public schools, and that Catholic adoption agencies should not be compelled to place children with prospective guardians who live contrary to the moral teachings of the Church. Such cases should seem to the political liberal largely indistinguishable from the more celebrated cases of the conscientious objectors who could not be conscripted in the military, the Seventh-day Adventist who should not be forced to choose between receiving unemployment insurance and working on the Sabbath, and the Jehovah's Witness elementary school students who could not be compelled to salute the American flag and recite the Pledge of Allegiance. Now, political liberalism, regardless of its shortcomings, could at least in theory provide some breathing room for religious and non-religious dissenters to prevailing cultural beliefs and practices. But since roughly the middle of this century's first decade, political liberalism has gradually lost its salience among our elites and has given way to what I call hegemonic liberalism, eschewing the epistemic modesty and emphasis on individual and corporate rights. It's a kind of orthodoxy that will not suffer heretics. Hegemonic liberalism seems to be in ascendancy in every major institution in the West. So I only got 5 minutes, so I'm going to just jump really quickly to eliminative egalitarianism. That view is a challenge because eliminative egalitarianism essentially says that there's nothing special about religion, that all deeply held beliefs, whether they happen to be consistent with or informed by conventional religion, should be respected. What's missing from eliminative egalitarianism is this understanding that there's a transcendent realm in which, to which we're ordered as human persons, and that we have a duty to God. So one of the things that stands out about Dignitatis Humanae is that there's more to life than simply this immanent realm, that human beings are ordered to the divine, that we have obligations and duties to God, and that the state should allow room for that. The problem with eliminative egalitarianism is that it simply says that there is no duty to God, there is no specialness of religion, and so you wind up getting these sort of very strange examples used by scholars in the literature, some of which were brought up the summer of 2022 in a talk that Justice Alito gave for the University of Notre Dame in Rome, a major address on this issue. And so I'm just going to conclude with to suggest something about how to think about Dignitatis Humanae, given the changes in the way in which religious liberty is thought. One of the things that Alito says in his remarks was, when the state signs on to protect religious liberty, it necessarily signs on to a particular conception of what it means to be human. But it seems, though, that the reverse is also true, given hegemonic liberalism and eliminative egalitarianism. When those in positions of cultural and legal power and authority sign on to a particular conception of what it means to be human, the state will inevitably sign on to a particular conception of what religious liberty means and protect it or not protect it accordingly. So if the principles of Dignitatis Humanae are to be advanced in this day and age. I think we have to develop a body of literature that responds to these challenges and that at least shows that the case made in Dignitatis Humanae is a rational and reasonable one. Thank you very much. It's all yours.
Great. Thank you for that very interesting talk. I think my talk has a lot of similarities with yours, so I think this will be a fruitful discussion. First off, I want to thank everyone at the DeNicola Center for Ethics and Culture for putting on this conference. I know firsthand it takes a lot to make a conference seem like it's running this smoothly, so especially if you see Brooke, who's over there, or Justin or Margaret, and anyone else that you see who's working, thank them for the work that they're doing to make it seem like no work's going on at all. For those of you who went to Marianne Glendon's talk, I'll be touching on some of the topics that she and Professor Sneed were talking about, and Professor Beckwith as well. I think, as I said, these all work well together. I'm going to start with a legal example from a case that happened a full 20 years ago this year, Lawrence v. Texas. So in that case, Justice Scalia pronounced the end of morals legislation because the majority in that case had said, quote, "Our obligation is to define the liberty of all, not to mandate our own moral code." Lawrence v. Texas involved sodomy laws that classified homosexual sodomy as different from just sodomy in general. Since that case, I think Justice Scalia's statement is in some ways a tad hyperbolic, and I think it slightly also understates just kind of how far the court had moved from morals reasoning by the time that Lawrence was decided. Like Professor Beckwith, I'm trying to condense a paper into 20 minutes, so I can't get into all the subtleties of what has happened across the doctrine, but I'll try getting into some of it. In that time, though, society has not taken a more libertarian turn necessarily. The current story of the modern era, as the prior talk was saying, is this increasing legislation and regulation, not just the absence of regulation touching our lives. So I argue that in lieu of morals justifications, borrowing a concept from Stephen D. Smith, the court and our legal culture has engaged in smuggling, rooting normative commitments through more neutral-sounding values. These values do not and cannot get to the heart of the issues in the law, but they seem appealing for jurists who wish to avoid the controversy that comes from making normative claims about the human person. It has done so by using two primary values, non-discrimination and public health, which seem like they're neutral consensus values, but are really fool's gold because they lack the meaning and content that we need in order to have a fruitful dialogue and discussion. So I'll proceed as follows. First, I'll give a brief overview about the role of morals legislation conceptually in the jurisprudence and what it's done in US history. I will then turn to what I think has replaced morals in this conversation, the public health and non-discrimination. And then I'll conclude by saying that I think it's worthwhile to consider, notwithstanding the challenges as a litigator, I'm aware that there are significant challenges to reincorporating a conversation about morals into our legal culture, but talking about how, as Professor Sneed said yesterday, this would bring back an honesty to our law that would be helpful. So traditionally, as lawyers know, there's this concept of the police power, which is the authority that the state has to make laws and regulate. The police power traditionally covers health, safety, and morals. There's also issues that it covers beyond that, but this is considered the core. The Universal Declaration of Human Rights, even though it's a rights-protecting document, recognizes the role of morals. Dignitatis Humanae, as was just discussed, recognizes that morals can come in to kind of put limits on rights. The European Convention of Human Rights, the Inter-American documents, all these systems recognize in text that you can have this potential moral reasoning in rights adjudication. I think this traditional understanding is best exemplified by a 1904 treatise on the issue, which talks about how there's the sphere of police power and an exempt sphere that the police power can't touch. that exempt sphere is of, quote, moral, intellectual, and political movements in which our constitutions proclaim the principle of individual liberty. The tension between recognizing morals and this liberty is clear. As the treatise explained, quote, health and safety are primarily subject to the police power, but all restrictive legislation should have the utmost regard for the freedom of science, art, and literature. On the other hand, and this is still a quote, religion and speech and press are primarily free, but that does not prevent them from being subject to restraints in the interest of good order or morality. As Mary Ann Glendon suggested yesterday, for a modern jurist, scholar, or lawyer, these two values, freedoms and moral restraints, may seem so in conflict as to risk potential war and anarchy. But in 1904, the treatise could simply announce that, quote, very little difficulty has so far been encountered in the mutual adjustment of these interests, end quote. As such, the Supreme Court recognized morals justifications also in tandem with other recognition of other types of interests up through around the 1960s, when you really start seeing this shift, as Mary Ann Glendon said yesterday, in the worldview and view of the role of the judiciary and judicial competence. So to contrast these very briefly with limited examples, one case from 1896, Hennington v. Georgia, involved the misdemeanor law about observance of Sunday Sabbath. The Supreme Court noted favorably a state Supreme Court decision that noted that consistent breaks, quote, reduce wear and tear, promote health, favor cleanliness, encourage social intercourse, afford opportunity for introspection and retrospection, and tend in a high degree to expand the thoughts and sympathies of people, enlarge their information, and elevate their morals. There was thus no distinction in this class between the Sabbath's physical health and moral benefits. These considerations, I think it's also important to highlight, were present in cases even that are seen as very strong rights cases. So Meyer v. Nebraska is considered one of the seminal parental rights cases. It stated that the government didn't have an interest in stopping parents from teaching their children foreign languages. But even in that decision, which is used as kind of the bedrock of these parental rights cases that you may be hearing about in the news, the court recognized this moral interest in religion, morality, and knowledge as necessary to government and the happiness of mankind. In this case, the government just hadn't shown that there was a moral harm in having students learn a different language. But by the 1960s, as I said, the morals justifications had largely disappeared in majority opinions. This shift, again, did not necessarily mean a free-for-all where libertarian ideals reigned supreme. Instead, these first-order morals considerations gave way to second-order and third-order harm arguments that could win the day. An illustrative example for this is Paris Adult Theater v. Slayton in 1973, which upheld obscenity laws for pornographic theaters. The courts held that a state can determine that public obscenity, quote, has a tendency to injure the community as a whole, to endanger the public safety, or to jeopardize states' rights to maintain a decent society. To wit, pornographic theaters cause moral harms. However, the court explicitly rejected calling these considerations moral. Instead, the state had the authority to make these, quote, morally neutral judgments. This decision is a muddled decision that can't make sense of the interests that it seeks to recognize. The court considered valid the same considerations that in Hennington were comfortably integrated into moral considerations, that, quote, good books, plays, and art lift the mind, improve the spirit, enrich the human personality, and develop character, while obscene books may exert a corrupting and debasing impact. But these were, for the court, quote, unprovable assumptions, end quote. But the court did not clarify what these unprovable assumptions like character development could be other than statements of moral judgment. Instead, they were morally neutral and therefore permissible. The reason for the shift seems clear. As I said, in dissents and concurrences, you see this debate among the justices about whether it's the proper role of the judiciary to be considering moral considerations. I think as we lacked a common culture of moral reasoning, it starts to seem more arbitrary and more like you're imposing your own idiosyncratic beliefs onto the general people. And I don't discount that as a jurist, these are very difficult questions to figure out. But the shift, other than in the 80s and 90s, where the Rehnquist court starts to seem like they might be willing to consider morals in cases like Washington v. Glucksberg, which I won't get into the technical discussions there. It is the case that Scalia's pronouncement in Lawrence is correct. You see this desire to make rulings based on these other types of interests and harm arguments. So what has taken this place, as I've said, it's the rise of non-discrimination health justifications, and in particular, I'll focus on in free exercise, partially because that's the area I work in, partially because I think that this is one of the biggest areas of movement in the current Supreme Court. I think that this non-discrimination language really sees its fullest application in the Fulton v. City of Philadelphia decision, which some of you may be familiar with. In that case, the City of Philadelphia attempted to withdraw from a contract with Catholic Social Services for the provision of foster care services. And the City of Philadelphia said that its motivation to stop this foster care placement was its declared non-discrimination interest in providing services to gay couples. Now, the Supreme Court in that case used the language of non-discrimination to hold the reverse, that the city discriminated against the religious provider, not vice versa. You can see even in this description of the case that there's this tension. You can't use the word and language of non-discrimination to avoid these deeper fundamental questions. Now, it's very clear to see why this has been adopted. Non-discrimination is a foundational value of our age. It's an overriding principle of our legal system. It very clearly has a role, a proper role in the legal system. Justice, and equality for all is indeed an important value. The language of non-discrimination has broad purchase. None of us want to be discriminators. Reliance on non-discrimination leaves for another day these deeper unresolved tensions. As a strategic matter, it puts you on the defensive. It makes sense then that in these areas of deep disagreement, lawyers and courts would rely on it. But there are issues with this over-reliance on and bloating of non-discrimination. First, as Fulton itself demonstrates, it's not a prudential, neutral legal value. As Peter Weston famously put it in a law review article that's decades old, the idea of equality is empty. And as Martha Minow has lamented in our discourse, quote, sharp disagreements now arise even over how different sides of issues are framed or called. This use of non-discrimination amps up rather than tempers polarization, notwithstanding the unanimity of decisions like Fulton. After all, who wants to reason with one's persecutors? Now, the public health comes in as an interest that the government can assert. So non-discrimination is also an interest the government asserts, but it usually protects against government action. Public health is what the government then uses to attempt to justify its actions. This has become an increasing area of litigation. The COVID-19 cases obviously provided the Supreme Court grounds to make determinations about public health, but even more fundamentally than that, these types of cases are coming down the pike and gaining more momentum in all sorts of contentious issues that will eventually reach the Supreme Court. Again, public health has some very clear advantages. The most obvious is that public health is indeed an important subject of government regulation. I think as society we may disagree on first principles, but only the most libertarian cranks are going to say that wastewater treatment's a bad thing. Also, public health claims ostensibly can be supported by data and studies, which a court may feel more competent to evaluate. It gives the sense that you can rule on neutral principles. However, the shoehorning of deep moral disagreements into public health causes more problems than it solves. First, a recourse to public health justifications does nothing to resolve the opposing views presented in these cases. Public health claims are made and evaluated on both sides to wildly opposing outcomes. A proposed safe injection site in Philadelphia invokes public health in providing drug users clean needles and supervision as they inject opioids. Meanwhile, Congress banned the practice because illegal drugs harm the health and general welfare of the American people. Arkansas banned transgender medical care for minors, asserting an interest in the, quote, health and safety of its citizens, particularly vulnerable children who are gender nonconforming or who experience distress at identifying with their biological sex, end quote. The United States opposed this law, stating that the care can be, quote, necessary to improve the physical and mental health of transgender people, end quote. While public health is not the first line argument in abortion, it comes up in both sides of that debate as well. So Mississippi in the Dobbs case quoted the interest in, quote, protecting unborn life, but also in, quote, women's health and the medical profession's integrity. Against this, New York strengthened its abortion laws post-Dobbs, citing health reasons for women. Public health, then, is clearly a stand-in for other first principles, and it is a naive, if not a category error, to rely on public health as a neutral way out of these contentious issues. Second, requiring a public health justification in court necessarily deadens or obfuscates the role that morals play in these debates outside the courtroom. When public health is one of the few currencies before the courts, everything becomes public health. Public health specialists have declared, quote, public health is everything and everything is public health, end quote. Public health claims have been made by public health experts that include gun violence and racism, loneliness and drug use, teen use of social media, domestic violence, and mass imprisonment. Areas where human volition comes more into play and for which religion would have once been seen as a dominant solution. At the same time, public health is facing institutional distrust. Part of this is how the public health authorities handled the COVID-19 pandemic. Partially, this is also because of this consequence of this blow. Third, if a law cannot be justified with morals when the inevitable legal challenge is brought, it means the morals-based reasoning cannot form the record that the court is judging when the court is ruling. But also, when morals can't be used as a basis of a sophisticate's reasoning, if a court or an educated professional can no longer use it in their thought, the culture itself shifts. This is not to say that law exclusively influences culture or vice versa, nor is it to say that the adoption of this public health language isn't itself a symptom of broader cultural and philosophical shifts away from a clear reckoning with first principles. But the smuggling of normative commitments through the public health lens worsens, not ameliorates, our culture's ability to discuss what's actually at stake in these decisions. Fourth, and importantly, public health findings may not be the solid ground upon which the court may rule as they think. The scientific studies that are cited are often, as one scholar has put it, policy-based evidence rather than evidence-based policy. The sciences are facing a replication crisis. There's even more fundamental questions about how you tailor the findings of your results based on the data that you're collecting. And these questions are difficult for the public health establishment and for scholars themselves to understand and to grapple with. Nonetheless, judges and the legal profession, who, as Judge Posner noted, very much enjoy saying they went to law school because they're bad with numbers. To conclude, these two approaches cannot fully capture the issues that are at stake. As Professor Sneed said yesterday, we ignore morals reasoning at our peril. As Hadley Arcus has put it, the logic of morals begets the logic of law. I cannot, in this brief discussion, get into the question of how this would actually play in practice. As I said, as someone who deals with cases, I understand that this is a tall order, but I suggest that morals reasoning could be a valuable tool to shape our current jurisprudence and a turn to clarity in our lawmaking. The resuscitation of morals reasoning is not one weird trick that's going to fix all of our societal dilemmas, but it could be important nonetheless. It could allow political debate to use the moral language that is currently curtailed when morals cannot satisfy legal scrutiny. It could clear up the conceptual confusion around what courts count as discrimination, and it would avoid thorny issues with public health evidence and judicial competence that legal culture has left unaddressed. To put it simply, to paraphrase Pope Benedict, it would help our legal culture become more honest, which may act as a small crack in the window to refresh our public discourse. Thank you.
Thank you for coming. I'm happy to be here for many reasons, but a new one is that I wanted to introduce a former student of mine, Santiago, with a new friend that I made here, Father Gonzalo. So it happens both to be here, so I'm happy for an extra reason. Charles Malik, one of the key architects behind the Universal Declaration of Human Rights, he believed that human beings could rise above life challenge, find redemption in even the toughest situations, and that the internal struggles we all face are actually part of what makes us great. Malik's fingerprints are all over the UDHR, making it unique. For example, he made sure to include the power of reason as something that recognized our duty to be empathetic and respect everyone's basic dignity. He also highlighted the family as a natural place for human rights to flourish. Plus, he championed the right to religious freedom even in the face of everyday challenge. And he stressed the importance of education in shaping well-rounded individuals. Malik also had a hand in writing the preamble of the Universal Declaration of Human Rights, which is the part that introduced and explained the rights listed in the Declaration. Back in June 1948, Eleanor Roosevelt asked him to come up with the preamble over a single weekend. At the time, the Declaration had already outlined its core ideas, but it was missing one important thing, a clear answer to the question, why do we need a Declaration of Human Rights? Malik took inspiration from the French diplomat draft René Cassin, who has suggested, starting point out, that the suffering caused by the two world wars was due to the people ignoring human rights. But Malik, drawing from his background as a philosophy professor in Beirut, decided to take a more positive and profound approach. He placed a philosophical statement at the very beginning of the preamble saying that recognizing the inherent dignity and equal rights of every human being is the foundation of freedom, justice, and peace in the world. Marian Glendon believes that this shift in the preamble reflects Malik's philosophical background. Before his diplomatic career, he was a philosophy professor at the American University of Beirut. He delivered many talks and lectures, which you can still find in the Library of Congress in Washington. In this paper, I'm going to explore how Malik's change to the preamble connect with some of those ideas he shared in his chapel talks, delivered between 1939 and 1944. It's about approximately 40 talks of exhortative and reflective nature for the moral education of those who listened it. This paper is divided into 4 sections, all guided by different insights that Malik shared in his chapel talks. These ideas serve as the backdrop for his proposal to the grant of the Universal Declaration of Human Rights, not solely in the tumultuous backdrop of the World War II, but more profoundly in the enduring essence of human dignity. In the first section, I explore Malik's idea of a deeper crisis than an economic or military tragedy. In the second section, I delve into Malik's view that human existence inherently involves crisis. Moving to the third section, we uncover Malik's belief in the pivotal role of literature in guiding us through this crisis and shedding light on the path to human flourishing. Finally, in our fourth section, I conclude by discussing the reclamation of human dignity as a dynamic quest. So moving to the first part, a deeper crisis. As previously mentioned, René Cassin proposed that the preamble of the Declaration should begin with a reference to the recently concluded World War in 1945. In contrast, Malik started from the more foundational perspective, the inherent dignity of the individual. In fact, as far back as 1941, in a talk titled The Inner Struggle, Malik pointed out, quote, "It's very difficult these days to get our minds off the Great War in Europe, but this rightful interest in the external struggle is beset with that great danger. The danger of undue absorption in the external distant struggle is to become blind to the inner struggle, which is taking place in our hearts all the time." End of quote. According to Malik, the most crucial battle takes place within ourselves as we strive to remain true to the values of true friendship and our faith in God. He went to emphasize, quote, "But I believe a deeper view of the character of the present situation is to see that this war arose because the rotten state of the human heart," end quote. For Malik, armed conflict and the injustice it spawned were undoubtedly problematic. Still, he believed that the solution lay in addressing the deeper aspect of human nature. He asserted, quote, "War is not at the end in itself. War is not for the sake of peace. A peaceful existence is not truly human, nor it is on any real value if it is not embodied with the intellectual, the spiritual, the theoretical, and the vision of what is true, good, and beautiful. In essence, war and peace are the question of the human spirit." The resolution to the human crisis, whatever evident in war or everyday life, could not be found solely in the economic, political, and military realm. Malik believed it must come from the inner transformation rooted in the pursuit of truth, beauty, and goodness. Overcoming fear means changing our perspective by discovering the truth about oneself, that we created beings inherently connected to others and called to act rationally for the greater good, which shines with the beauty of truth. Malik put it in this way, quote, "Then perhaps they will replace the fear of things with the fear of the Lord. When you truly come face to face with this living truth, when you see it taking on flesh and blood in the existence of the real person before you, then nothing in the world will frighten you." End quote. Second section, human existence in both crises. According to Malik, living as a human being with a personal dimension inherently entails experience crisis. Some crises are self-inflicted because we do not live the truth of ourselves. Others are brought about our relationality, external factors, and yet others emerge from our encounters with truth, reality, or the divine when we discover that we are not what we thought or what we should be. This is about the crisis of not living the truth of ourselves. And if we manage to live in that truth, the crisis shifts to the fact that we are unfinished beings who must reclaim maturity with our freedom again and again. Regardless of their origin, just as Malik recognized the dignity of every individual, he contended that this dignity could only be truly grasped within the whirlwind of a crisis. As he put it, quote, "The crisis does not refer to a condition of weather or to a state of the mountains. The crisis means literally a crisis-ridden man," end of quote. The truth about ourselves remains a riddle because we are not self-sufficient beings. We are creatures born from others. We live alongside others. We find the purpose of our existence with them. Therefore, there will always be something unfinished and hence a crisis to resolve in our life. By relying on others, we are perpetually exposed to the joys and sorrows of human relationship and the quest for connection with the divine. According to Malik, this vulnerability and interdependence were factors that shapes the critical nature of our human life. The second aspect contributing to the critical nature of our existence, according to Malik, is that humans often do not live in the truth of themselves. In several of his speeches, titled like The Inner Struggle or Seeking or Abortive, Malik discusses how people frequently become ensnared in the pursuit of fleeting satisfactions and pleasures rather than exploring the truth of their own nature. This error is not only theoretical, but affects how we live our lives according to this truth. To go astray in this search or even to cease seeking means living in a state of crisis. The third section, literature. Malik encouraged his listeners to take their crisis seriously embrace them, and walk with them in the pursuit of happiness. Such a struggle is not one we face in isolation. We learn to comfort it when we observe specific individuals who succeed in living the truth. As he emphasized, quote, "We can never achieve any measure of personal truth unless we ourselves come in contact with other people who are themselves actual, complete persons," end quote. So where do we find these people? In true friendship, in the authentic communities to which we belong, in religious community, or under the guidance of a mentor. Regarding to mentors, Malik suggests that when we see them, it awakes in us the desire of witness the moments of truth that they see. Quote, "There are three places where we can get the heart of the man: in great literature, in philosophy, and in religion. In these three activities, man himself is brought out, this curious mixture of deity and humanity, of the highest greatness and the best buildness. These people teach us about ourselves, and therefore help us to see how hard times are seated in our hearts if you really understand a play by Shakespeare or a novel by Dostoevsky. We should have read great literature already. We should already have disciplined fortify our souls to face and go through hard times. We should already have purified ourselves of any illusions about the nature of things, because it is sadly the case that most of us have not already subjected themselves to the discipline of great literature, and therefore still suffer from much illusion. They fail even to notice that hard times are upon us," end quote. Malik carried this concern with him and shared with his fellow drafters while advocating for Article 1, with its mention of dignity and rights discerned by reason as duty of fraternal empathy, and during discussions about religion freedoms and family protections. Explaining these arguments is not the focus of this paper, which aims to concentrate on the chapel talks as Malik's intellectual framework in drafting the preamble. However, I must make an exception here. In June 1946, the Commission of Human Rights was just established, overseeing the drafting committee of the Declaration. Malik was part of both bodies. By August 1946, Canadian John Humphrey began assembling documentation on rights that could be included in the future bill. Meanwhile, in late June that year, 2 years before his proposal of the preamble, Malik suggests to his colleagues at the UNESCO to publish a translation in various languages of 50 classic books that reflected the philosophical project of the United Nations while promoting common understanding among all nations. Quote, "For man does not live by bread alone, he lives by ideas and convictions. The ultimate grounds of war and peace are not to be found not in his economic and material needs, not even his social needs, but in the truth or error of his mind and spirit," end quote. In Malik's vision, UNESCO roles was to raise the standard of thinking and feeling, as cultural development was just as vital as material development. Cultural underdevelopment often leads to economic backwardness, and the ultimate causes of war and peace are found in the truth or error of people's mind and spirit. Malik believed that the doctrine of the classes was the doctrine of humility. It acknowledged that the true and value exists outside oneself, captured and known by someone else, which one must seek and find. It is also a doctrine of progress, pushing individuals out of stagnation and petrification towards something better. It emphasizes excellence and quality because it affirms that there are masters, authorities, norms superior to the ordinary and commonplace. In the knowledge of these masters, individuals attain their highest freedom. Therefore, it is a doctrine of liberty. Finally, it's a doctrine of peace because understanding the ultimate and true viewpoints of others leads to peace. targeting the human heart and its formation, recognizing connection with others within a culture were part of what Malik argued for in the context of human rights and Universal Declaration. Therefore, the Declaration needed to be justified in its preamble, not only in response to a serious problem like the World War II, but on a deeper level. For instance, we can understand Malik's arguments about the role of literature, great books, and the translation of the classic from all cultures to make them available to everyone. Quote, two extremes must be avoided, two extremes of false internationalism, whereby a thin least common denominator of culture is envisaged, and the extreme false nationalism, whereby the literature intensifies of one or a few nations are imposed upon the rest of the world. The former produce abstract uniformity without character and depth, the latter external blind conformity by compulsion and force. Malik's initial list suggested classics included the Wisdom of Confucius, the Dialects of Plato, the Summa Theologica of St. Thomas, Dante's Divine Comedy, the works of Shakespeare, Cervantes, Don Quixote, Tolstoy, War and Peace, among others. Section 4. Considering that we are exploring thus far two significant consequences of the inherent crisis in human existence as derived from Malik Chappell's talk come to light, it is crucial to recall Malik's proposed alteration to Cassin's preamble. Initially, the preamble points to the devastating human tragedies brought about by wars, but after the Lebanese amendment, the Universal Declaration now was rooted in the recognition of the intrinsic dignity and the equal and inalienable rights of human beings. The alteration might seem subtle, but it imparts a profound lesson. While it's evident to the drafter that dignity encompasses both the intrinsic value and the individual and the freedom to live according with it, Malik's reflection brings to the forefront the recognition of the fears and crises inherent to existence. The very essence of freedom implies the achievement of peace and development is never one time, forever attained goal. Instead, as true freedom dictates, justice and human rights will perpetually be a gift to uncover, a challenge to surmount, a creative solution to generate, a response to convey, and a tradition to perpetuate. Conclusion. In conclusion, according to Malik, the greatness of human dignity and its vocation means that the radical value of human existence is not achieved without embracing the existential crisis of someone who is incomplete, fractured, broken, living in doubt. As he put it, quote, every one of us is a question, a fundamental question. You only have to look at our ears to see two unmistakable question marks stuck to our very being, end quote. It also means that one must strive to find their personal place by learning to live alongside others without being consumed by them, despite all the difficulties this entails. This insight from Malik and the title of this conference reminds me one of a famous sonnet by the Spanish poet Francisco de Quevedo. But before I read it, let's create a little crisis in you. You see, this sonnet is so captivating that we have to experience it in its original Spanish charm. I'm going to read in Spanish, sorry. Alma a quien todo Dios prisión ha sido, venas que humor a tanto fuego han dado, médulas que han gloriosamente ardido, su cuerpo dejará no su cuidado, serán ceniza, mas tendrán sentido, polvo serán, mas polvo enamorado. Now, just as you experience a crisis of listening a foreign language, I'm about to encounter my own crisis, which is written in a foreign language. So the translation of the same poem. So it says, soul by no less than a God confined, veins that such of a blazing fire have fueled, marrow to its glorious flames consigned, the body will abandon, know its woes, will soon be ash, but ash that is aware. Dust will be, but dust whose love still grows. I be bonds, but I have loved you. That's the point. Thank you.
Thank you very much to all of our panelists, and thank you for being so timely. We do have about 15 minutes for questions, and there will be a microphone that comes around so that everyone can hear. So, questions.
Thanks much. This is mostly a question for Frank, but I want to bring together themes from the first talk and the third talk. It just seems so important for us to continue the unfinished argument of Dignitatis Humanae. It sort of lays things out, but leaves to others to fill in the argument. And it seems to me there's plenty more work to do that, but it's tied into these translation issues. We just heard at the end this brought to the fore these issues of translation. But the translation that your talk pointed us to is that, look, we all speak the languages of modernity now, whether it's English or Spanish or French. They're all international languages, except Gaudium et Spes says the central terms are used in different ways. So the language of rights, right, that is endorsed in Dignitatis Humanae, the right to religious liberty, right, we hear as Lockeans where Dignitatis Humanae is explicitly saying, but it should be understood in light of Catholic anthropology. And I mean, that just seems like a very profound problem that's central to continuing the argument of Dignitatis Humanae. I think there's a question there, but maybe you can comment on that.
Yeah, it's on. I reread Dignitatis Humanae about a year ago. I am working on a larger project on religious liberty, and I had forgotten how Catholic it was. I mean, and I think what really kind of hit me was, because I spent the last decade just reading secular authors who have doubts about religious liberty, and to read Dignitatis Humanae now, it's almost like reading a medieval document. It doesn't, it's always portrayed, and rightfully so, as a sort of the church's, dealing with its history as well as the current climate of the Iron Curtain, and that's all true, but the language is so tightly tethered to, the perennial way that the church has talked about human nature, but also a lot of the encyclicals and documents that were issued by numerous popes from the beginning of the 20th century onward. So, but yeah, while working on this paper, I would read non-Catholics, secular writers, including Ronald Dworkin, who talks about, he doesn't refer to it as Dignitatis Humanae, but he reads it as a Lockean document. So I do think, I think the challenge today for those of us who believe in religious liberty is to defend, kind of go back to kind of old-fashioned apologetics. Is this document's claims about human nature in fact true? And I think today the doubts are pretty deep in the literature. There's a book by a philosopher named Brian Leiter. I don't know if any of you've heard of Leiter. He is the editor of the Philosophical Gourmet, which is this ranking of philosophy departments. And in his book, Why Tolerate Religion, he begins the book by talking about this case of a young Sikh man who, actually kid, he's a junior high kid who wants to wear a kirpan, which is a ceremonial knife. And Leiter says, look, in most liberal democratic countries, this kid's going to get an exemption from general laws against carrying weapons to school. But what about the kid who carries the family heirloom knife That's deeply important to him as well. And so the question that I raise in the paper, which I didn't get to bring up, so, well, what if it was the same kid? Like, what if the kid who wore the kirpan is also the kid who carries the family heirloom? Wouldn't he be able to tell the difference between a sacred object and something his grandfather gave him for carving things? And I think one of the things that's missing in a lot of the secular literature is just a complete ignorance of what, like, religious people believe. There's an attempt to, you've got this way of looking at rights and the obligations of government, and you've got this weird thing called religion. How can we explain that to fit the categories we already have, rather than taking religious believers' claims as they see it? I think that's the project. Anybody else? Okay.
Thank you. Louis Pearson, University of St. Francis. Thank you for all of your papers. The question's going to be about language. I think any of you can answer it. Frank, you said something about a decade ago. There's an accusation against something you said or did, and you said, I take that slur, that charge, and I raise you rhetorical McCarthyism. And how, Professor Matozzo, you said we're often on the defensive now because who can be anti-study or anti-whatever? Because we're not talking about morals, we're talking about something that we can all look at together. I was wondering if you had anything to say about how it is the use or abuse of language, or the reclamation of a proper frame to use the language to move forward on the projects that you're all talking about, what that might look like.
The issue of language. So think about, this is one of my pet peeves. So in the Masterpiece Cake Shop case involving Jack Phillips, the baker that refused to design a cake for a same-sex wedding, one of the things that's missing in all the court cases, and even the way in which some of the attorneys argued for him and against him, is the fact that weddings have liturgical significance for religious believers. It isn't as if weddings are like birthday parties and barbecues. And yet there's a tendency to not look at these particular activities as having religious significance. You think about where the issues, the conflicts in religious liberty really lie. They usually involve birth and death and big events in between. Like weddings, right? And it's because religion answers those questions. And what I find missing from the legal literature is any sort of acknowledgement that this is why there's a conflict. And so I think in terms of the use of language, I've tried in my work when discussing where these conflicts are is to sort of use the language of when it's appropriate, of liturgy when it deals with that. So a couple of years ago, I was giving a talk at University of Pennsylvania Law School, and I used an illustration for the students that were in the audience who didn't agree with what I was defending. And I said, imagine if you had a local Christian congregation that went to a Jewish photographer and wanted to hire him to take photographs of the baptisms of the church. And it turned out to be, the name of the congregation was Rocky Mountain Jews for Jesus. Don't you think that it would be, to use anti-discrimination law to coerce that Jewish photographer to participate in a liturgical event that he considers to be apostasy is outrageous, right? But once I took it away from wedding, it became much more obvious, right? So I do think that that one of the tendencies is to try to find some sort of secular equivalent language to explain religious events and activities, and I think that just gives away the store. So.
Yeah, so I think in this paper, I wasn't able to get into it, but it's part of a larger paper talking about this issue because I think it particularly pertains to freedom of religion in that if you tried to avoid having universal concepts behind these words that we're using. So employment division versus Smith, which is the case that governs free exercise doctrine, says that if a law is neutral and generally applicable, your incidental burden on religion is not something that rises to like a heightened level of government scrutiny. That was motivated by Justice Scalia's concern that each person could become a law unto himself. And in Lawrence, the case I started with, that is also something that motivates his dissent, as he talks about the law has to regulate conduct. You can't regulate belief, but it has to be able to regulate conduct. So each person can't say, this is what I believe. So I think because we're not able to have a shared conversation about terms like morals and whatnot, you start getting these other concepts like harms and third-party harms and whatnot that are used to deal with that fact that I think, are all kind of concerned with this idea that nobody thinks that you can have a legal culture. I don't think in practice people think you can have a legal culture where you are able to get away with everyone just living their own defined versions of things. So yes, I think that that's where we're currently at in the jurisprudence.
Yeah, please.
Hi, thank you for your talks. So I have a question about political liberalism. And the difference between political liberalism and maybe what you were calling hegemonic liberalism. Because you characterize political liberalism as the acceptance of the plurality of all values, and we'll focus on that. But even in its heyday, it seems political liberalism was not accepting of absolutely every value. For one, slavery was still not deemed something that was acceptable, even though there were people who really subscribe to those views. So I was wondering if you could crystallize for us what the difference, what the line is, how, because I'm presuming that a lot of the people who are proponents of what you have called hegemonic liberalism, although they probably wouldn't call it that, see it as an extension of like protecting the rights of gay people and other marginalized groups.
Yeah, so you mentioned, so the kind of liberalism, when I was referring to political liberalism, you mentioned slavery. So when the United States allowed for slavery, it was in a sense it was a liberal nation insofar as it appropriated the ideas of thinkers like Locke and Montesquieu and others. But I distinguish that from political liberalism in terms of the movement among a certain group of philosophers and legal scholars post-1960s, a kind of, like the state should remain neutral on these sorts of questions. So the example that of the philosopher's brief in Washington versus Glucksberg is sort of the paradigm case, because it's, people have different views on the meaning of life and death. The state shouldn't take one view on that at all. But we've gone from that to now it's dominant in the bioethics literature, scholars arguing that physicians should not be allowed as a matter of conscience to in any way if they don't want to participate, let's say, in an abortion or a case of physician-assisted suicide. So we've moved from everyone's got a different point of view on this to there's really only one point of view on this. And you mentioned, yes, I think a lot of hegemonic liberalism is, in a sense, it may be the result of just a general dissatisfaction with political liberalism. So it may be sort of the progressive opposite of what we see on the right. So you have the promise of liberalism is that we live in this society where people are free, and then the observation is, well, we're free, but people are still marginalized and treated badly, so maybe there's something wrong with political liberalism. And I think you see the reaction on the other side as well. You find people, especially the ascendancy of ideas like integralism among Catholics and Christian nationalism among some evangelicals. It's like, you guys made this promise and you're not fulfilling it, so maybe there's something wrong with that. So I'm not addressing, my point is to sort of make an observation about the changes, not to sort of address like how necessarily to respond to it. But my point is that the fights and the disagreements are just going to be different today, and it weren't like what the church was facing in 1965.
So we're right at noon, so I think we unfortunately don't have time for any more questions, but please join me in thanking our panelists for their discussion.